Good morning. Welcome. It's a pleasure to have you here today. We have one matter on our oral argument calendar this morning. It's Shuman versus Shuman, and it looks like counsel is here and ready to go. I'll just give you a couple of reminders. We are live streaming this matter, and so if you'll please speak into the microphone at the podium, we will be sure to record everything you say. Please introduce yourselves when you come to the podium and also introduce those at council table with you. And then it looks like you've reserved 2 minutes. Okay, so your clock will start at 13. Once it hits 0 on your opening argument, you'll be in your rebuttal time. All right, thank you.
Good morning, Your Honors. THEODORE WECKEL on behalf of Wesley Shuman, who is present today. Your Honors, this is an opportunity to correct an injustice that has occurred for 3 children as well as for a non-custodial parent. It's also an opportunity to expand and to give further guidance on the case Hudema versus Carpenter. Now, in this case, the district court relied primarily on Hudema to say that the custodial parent, and these children, it was an unusual case in the sense that by the time that the case was filed, it didn't go to trial for 5 years. And so there were 3 relocations that occurred, and the mother did have custody of these 3 younger children for a period of 5 years. And so the court gave great deference to that fact and just said, you know, you got a high bar and you're going to have trouble, you know, overcoming that. But what we had...
There seems to be a factual question about those 5 years. Are you acknowledge that mother had custody during those 5 years?
She had physical custody.
And there was the question whether she had legal custody?
The court, the initial ruling by the commissioner was that the parties would share joint legal custody. And then the order was not prepared properly, and so it was just sitting around with each parent having split custody of different children.
So the legal custody was not ordered at the time of the filing of the...
At my understanding, Your Honor, it was ordered, but then what happened shortly before trial, I caught that error.
So there was no objection at the time?
I don't believe there was, Your Honor, and I was not the original counsel, but I believe that the error was just sitting there. However, the commissioner went back and she changed the order before trial, and she corrected and said that it's joint legal custody.
But is it a retroactive change, or is she just changing it as of that date?
You know, I don't recall, Your Honor, but I believe that the implication was it was retroactive because it was trying to fix the original order. It was just misstated. It was a clerical error.
And did she make that clear, or?
I think it is in the order. If you look at the order, I believe that it's fairly clear that the parties were to have joint legal custody. Okay.
But that's sort of an order. It's a little odd for that to be a non-protunct order, right? Because it governs the party's conduct in the past.
I agree with you.
So the the retroactive aspect of it seems to be kind of in name only.
Right.
Right?
I agree with that.
So my question is who in fact, I mean, exercised.
Yeah. I think the parties relied upon the original order and they exercised custody in that vein. You know. But I'd like to move on if I may.
Yeah, but you do make quite a big deal about that in your briefing.
Well, it is.
And you accuse the court of misstating what happened in the case.
Well,
in its findings.
Yeah. I think the district court placed very little weight on the fact that the commissioner originally made a ruling of joint legal custody, and we corrected that problem prior to the trial. So the court was aware of that and didn't really discuss it or anything at trial. You know, but we brought the error to the court's attention. But let me move on. So you're quite familiar with this case, I guess, factually, so I'm not going to delve into those facts right now. However, I think the opportunity for here is to show that relocation really has an opportunity to, the term is gatekeep, you know, is to block out the non-custodial parent from a relationship with the children. And this is what happened in this case. Mother moved 3 times. She moved once to Colorado and then once to Wyoming. And then there was other behavior which also indicated that she was attempting to block the relationship between the children and the father.
When she moved, wasn't there at least one of those, there was a stipulation by the parties that was?
No.
There was never?
There was no stipulation. There was originally a motion to relocate to Colorado, and that went before the commissioner. My understanding is that, and again, I'm second counsel in the case, was that there was an objection filed to that by Mr. Shuman, but there never was an evidentiary hearing for some reason on the Colorado issue. And so that issue certainly could have been addressed as a factor with the court's discretion in this case at trial as to how, if this was in the best interest of the children. There was plenty of evidence that the children were not doing well in Colorado, particularly the oldest child. And then the second relocation to Wyoming was supposed to be incorporated into the trial, the evidence presented, et cetera, and there never was any discussion whatsoever on that in the findings of fact or the final order. So we have 2 different relocations here.
But did she notify him of that second move?
She did. I don't know. I don't believe she filed under the statute, Your Honor, the required notice, but I believe that she did notify him orally of that, and he was aware of that. But the point was, Judge Toomey, was that we were going to bring this evidence and this issue before the court, the district court, at trial, which we did. We presented evidence as to this. So as opposed to, because it was such, the move happened right before trial, and so rather than just going through the rigmarole of filing an objection to the Wyoming move, we just did the evidence at trial, and that's how we did it. So there's the one point there is to expand and to really get into and comment upon how these relocations affect children. Secondly, and this is more of a minor point, but in HUDEMA there's language as to the religious compatibility with the parents. In this case, mother has called in one of the court pleadings the LDS Church a cult, and we have one of the children, there's evidence that the 12-year-old child was a fairly religious child, and so this is also an opportunity to elaborate on that particular point factually. Okay, so we're all familiar with the HUDEMA principles. My time is going very quickly here. I'm going to skip that. But what we do have here is we've got a remarriage. We've got, again, 3 locations, and the language in HUDEMA was, the bar is lowered when, in this one time, when mother moved with a new husband to Arizona, and the bond with the father was better, and the court said, no problem, we're going to keep the kid here in Utah. This case is really off the charts. I mean, we have the 2 relocations out of state, and then we have the 16-year-old girl who's cutting her wrists, who's sexually active, smoking pot, taking 20 Benadryl blister packs, not doing well in school. None of this is given any weight by the district court. Much. I mean, they may have alluded to it vaguely, but there's nothing in terms of weight given to this. The 12.
Didn't the court? I'm sorry.
Go ahead.
Didn't the court give some weight, though, to the deteriorating relationship between that older child and your client?
They did, but that was because the evidence was that the father, as a good father, was confronting the daughter and saying, honey, you're smoking pot and having sex. Where are you getting it? This is not a good thing. And he went on the phone and he was trying to, and we have the tape, we have it's evidence, okay? And the court said, oh, well, you were trying to, it's your fault that this relationship is bad because you confronted the girl about her problems. That's what happened. And, dad is like, well, I was trying to be a dad. And so I don't think the weight given the court on that particular point, Your Honor, I think was wrong, okay?
Mr. WECKEL, in all the argument you've made so far, you seem to be arguing that the substance of the trial court's decision, that is, the relative weight it gave to various facts and its ultimate decision was unreasonable.
Agreed. I mean, the findings of fact, I think, was clear error.
But the way you've briefed this case is that the findings were inadequate. That is, an inadequate findings challenge goes to, and you're obviously aware of this, you discussed it in your brief,
yeah.
you know, the sort of Stonehawker versus Stonehawker question of, can we follow the court's reasoning? Are there sufficient findings that
Right.
we understand the basis of the court's ruling
Right.
in the end? Or were there aspects on which the trial court was required to make findings and did not make them, and therefore the findings are inadequate or incomplete? But that's not the argument you're making today. You seem to be arguing that the trial court just got it wrong, and that's a different argument.
I do allude to that argument actually in my brief, Your Honor. I believe it's in the, in the first part of it. I say in the alternative, certainly the findings of fact were clearly erroneous. I mean, the evidence was presented. The court didn't weigh these things, correctly. It didn't. The conclusions that it came to just don't follow from the findings. So I agree that there's that aspect to it. But I also did say.
So I guess I'm confused about what your argument is. Is your argument that the trial court's findings were clearly erroneous in the sense that the clear weight of the evidence was on the other side, or is it that the trial court's findings were inadequate in the Stonehawker versus Stonehawker sense, that the court didn't find all the facts necessary to show its work, so that we can see why it made the ultimate decisions?
I argue in the alternative, Your Honor, for both of those points. That's what I thought I said in my
okay.
opening brief, but I think they both apply in this case. Regardless, it's clear that the court got it wrong, Your Honor.
Well, if it's a challenge to whether the findings were clearly erroneous, then isn't Mr. Honeycutt correct that you need to marshal the evidence?
No, Your Honor, because there's also, and I very late in the day, but we had until you actually make your opinion. But I did file the 24J notation, and I cited to the Barnes case where the marshaling requirement is not necessary when the facts are so off the wall, so to speak, with all due respect, that they don't even correlate to what the evidence is. And so that's what I said here. Yes, there is technically a marshaling requirement. However, this case is really poorly reasoned, in my opinion, and not weighed correctly. And so that particular requirement is dismissed in that case. And I'll just reserve the rest of my time here.
Let me ask a quick question before
Yep.
you sit down. Isn't the oldest child that's at issue in this order about to reach the age of majority? She'll be 18 next month, isn't that right?
She was 16 at the time of the appeal, at the time of trial. May I indulge? I'm not sure
Sure.
of her age. So yes, you're right. She'll
All
be
right.
18
Does that
next
moot any of the issues in this case if we were not to reach a decision before June?
Are there any issues?
Are there any issues that would be mooted by the fact that she's going to be 18?
I think it's a huge issue, actually, because you still got the two younger kids. One of the issues is keeping the siblings together and the custodial factors. And now that the child who's 16 is gone, she's an adult, I think then that's even stronger reason to just ignore. It's not important that she wants to be with her mother because she's now an adult. So I think that moves even closer, more strongly in favor of the appellant's position.
Thank you. Would you please just introduce who's at council table with you?
Pardon me?
Please just introduce who's at council table with you today.
Oh, this is Mr. Shuman.
Okay.
Yes, this is Mr. Shuman.
Thank you, sir.
Thank you.
All right.
Good morning, Your Honors. My name is James Honnicuttt with the law firm of DOLOWITZ, HUNNICUTT. With me at council table, farthest away from me, is Julie Sagers, co-counsel on this case. And sitting in the middle chair is the petitioner and the appellee, Catherine Shuman, now known as Catherine Lay, since her remarriage. Your Honors, I feel like the findings of fact and conclusions of law in this case pretty much speak for themselves. I think it's pretty clear the district court judge worked really hard to sort out a very messy situation. I think most divorces that go to trial are pretty messy. This was one where basically everything was being fought over. Child custody, obviously, parent time, the value of certain assets, how debts should be allocated, etc. Basically everything except for alimony was being fought over. And I sympathize with any judge who's put into that position where they have to sort through a lot of noise and come up with some sort of answer that speaks to all the issues that's been thrown And I believe the findings of fact and conclusions of law very carefully and thoroughly achieved that goal. The case that was brought to our attention last Friday, for example, this Barnes case, it's pretty much the opposite. Where the judge says, well, you know, I'm going to look at factors, I'm going to look at these factors, but doesn't actually nail down what those factors were in relation to the facts of that case. Here, in Shuman versus Shuman, he worked really hard, the district court judge. He did a great job connecting the dots, talking about specific examples of evidence and how they led to the decisions that he made. Before I forget, I want to respond to a few of the points made by counsel. And I think Your Honors have dialed into it pretty well.
Thank you.
At the start, we did a motion for temporary orders, and we went and argued in front of Commissioner Tack. The minute entry says what it says. I think the minute entry was the error. I don't believe the actual order signed by the court was the error. At that moment in time, Mrs. Shuman was represented by yours truly, and Mr. Shuman was represented by a very good law firm that does lots of family law. We weren't going to screw that one up. If Commissioner Tack had said, joint legal custody is what I want, everybody, that's what we would have put into the actual written order. It was no accident that we wrote in the order together. Me and Mr. Wall wrote it very carefully. Sole physical legal to my client of the youngest three. Sole physical and legal of the oldest child to Mr. Shuman. It's pretty straightforward, easy stuff.
Mr. WECKEL argues in his brief that there's other things in that order that suggest it's joint legal custody. For example, they both have access to medical records and school records, those kinds of things. What's your response to that?
In the world that I live, Your Honor, those types of extra little provisions don't transform a custody arrangement from sole physical to joint physical. We get creative all the time with our orders in the strange realm of family. And we're going to add in extra little provisions here and there. And I think it's very commonplace these days that a non-custodial parent will have rights to medical files and other rights without having joint legal custody. Frankly, I do that frequently. And if we're changing that, I find that really interesting and not something I would really advocate for. But that's not what we're here for. So I don't think it transforms.
That's more a
it.
matter of a right to access information about the children, right?
I concur with that completely, Your Honor. I mean, for example, the advisory guidelines under Section 30-3-33, that doesn't create a joint legal custody relationship. All those nice factors that we add into all of our custody settlements, you know, we're not going to take the kids out of school without a joint agreement. We're not going to, keep each other from special events in the children's lives. If you agree to those Section 33 parameters, you're not agreeing to joint legal custody. So I feel very comfortable saying we had sole legal, not joint, and that nothing inside the temporary orders or the amended temporary orders changed that. It wasn't changed right up until, a couple weeks before trial, and I'll never understand why that happened, because I was not on the case. My client was pro se. I think what happened was in the e-filing, a proposed order was submitted by Mr. WECKEL, and I guess Commissioner Tack looked at it and said, I must have meant that, and signed off on it. I find it pretty bewildering that came into existence. It was most certainly not nunc pro tunc. You look at that order that was entered, I believe it was August 2015, nothing about it suggests it's retroactive. And as Your Honor acknowledges, I don't know how we do that anyways. There's no time machine that goes back 5 years to say, well, now we're going to start communicating, we're going to start making decisions jointly. A lot of the emphasis I heard earlier from counsel was about the relocation, which I found really surprising because that's not really the focus of the briefs. And furthermore, only the first relocation was really fought over. The first time that there was a relocation from the Salt Lake County area out of that area, I believe when my client was moving to Wyoming, that was fought over.
And eventually ended up with some terms that they could both live with about dividing transportation and things like that. But as I understand the second move, she actually moved closer.
Exactly. Thank you, Ron. So the first one was fought, but then after that fight, it was over. And they stipulated, they nailed down some parameters for how to do exchanges back and forth, and it worked. And then the second move, the judge made a very specific order, or I believe it was the commissioner saying, it was the judge. If you're going to challenge this other move, this is what you need to do. And Mr. Shuman didn't do it. So I believe the primary issue of relocation really isn't a primary issue, and that matter was waived knowingly by Mr. Shuman. Now, I think it was at a point in time when he was not represented, but both of these people were not represented for a long time. And that doesn't water down the fact that you've made decisions and you've taken positions in your ongoing legal fight.
Mr. Weckel makes the argument that that's part and parcel of mother's attempt to gatekeep the father and essentially require him to in all ways go through her to deal with the children. What's your response to that?
Right. Well, happily, the judge made findings about that the two youngest children are allowed to have a great relationship with their dad when they're in the custody of my client. When they get to do visits with their dad. I mean, my rebuttal is he's just wrong. I mean, the evidence didn't suggest that. The guardian ad litem certainly did not support that. The two youngest children have been allowed to love their dad. Their mother encourages a healthy relationship between Mr. Shuman and the two youngest, and the three youngest children. And obviously the district court judge made a contrary finding about Mr. Shuman, that he stood in the way, that really he was the gatekeeper for the three older children who've grown to resent my client, apparently. They testified against her at the trial. And obviously the district court judge found that compelling, that Mr. Shuman made a decision to put his, I believe at the time, 18-year-old daughter on the stand, testify against my client. You know, I'm sure you've looked at it, but to me, one of the most compelling, if I have to boil this case down to one single piece of paper, it's that Deseret News article. We included that in our addenda, I believe, behind tab C. And I mean, that article, it just speaks volumes, and it breaks my heart whenever I think about it. Because in that article, you have a child who was 14 at the time. She wrote this letter to the editor of the Deseret News, our local newspaper, where she blasts her mother. She doesn't even say my mother. She says my biological mother. My biological mother went to court and lied to the commissioner for 45 minutes. You don't have to be a custody evaluator or a PhD in child psychology to know how that letter came about. It was blatant evidence of parental alienation efforts by the father. And the GAL picked up on that, and the district court judge picked up on that. So when I hear counsel say that the factual findings in this case were just completely out of whack and and just off the wall was the phrase I heard, I'm just left scratching my head. Everything that the district court judge found is grounded in the record. We didn't have to marshal evidence, by the way. Counsel briefs that I had some sort of responsibility to marshal evidence. I don't, but I did anyways. And I believe you probably recognize that in our brief, I point out the findings of fact, and then I pointed out all the records, the record citations, where the support was for what the judge did.
What about the debt schedules? I mean, Mr. Weckel includes that table in which there are rather glaring inconsistencies between the financial disclosures filed in the divorce case and the financial disclosures, or the debt schedule, or whatever it's called, filed in the bankruptcy. I mean, those seem like pretty obvious and demonstrable inconsistencies, no?
Well, Your Honor, part of the difficulty there is Mr. Weckel didn't really examine my client thoroughly on some of these things at the trial. So to the extent that she has explanations, I don't think the judge was given an opportunity to dig into these alleged discrepancies that were brought up after the fact. I mean, I acknowledge that this chart was brought up in that post-trial motion, but the moment to bring this high level of detail was at the moment during the trial. And it's funny because I've spoken to my client, and if we're going to reopen the evidence, we could talk about why there are some discrepancies here and there. But for the most part, I can do it without introducing new evidence. So let's go through it. On that Ford truck, I don't even know why they're bringing this one up, because that was awarded to him. He wants the number to go down. So one of the things you do when you're preparing for a divorce trial is you look for places to create some level of compromise. Where can I give up rent? That's what we're always doing as divorce lawyers is, all right, we could fight about 5 million things, or how about 1 million things? And what can we trim down? And so, sure, she dropped the value of that vehicle. That helped him in the divorce case. It didn't harm him to do it that way. They create this claim that she omitted the tile cutter. If you go down, I'm looking at, I believe this is page 44 of the brief of Appellant. If you go down to the bottom row, they're talking about, oh, she omitted a tile cutter. Your Honor, go look right there. It says tile saw. I guess we should have called it a cutter instead of a saw, but that's the way it was put in there. They talk about the laser machine.
What about the 40,000, the third row down, the 40,000 versus 13,000?
Let's see here.
Discrepancy of 27,800.
Well, my understanding is that the 13,000 in the second column there, they're saying that's just the value of half of the joint items. I believe what she was doing is she was listing the items that were in her possession, not the items that were in his possession. Am I saying that correctly?
I'm not sure which line of them you're speaking of now. Yeah, I believe so. I do know that there's a strong difference in the laser itself, which was a difference of about $15,000, because originally when the laser was in my possession, we were including the entire laser, but then the laser tube itself was replaced, which was about a $10,000 item, which no longer was part of the line items. There were a few things like that.
Mr. Honeycutt, if you need to consult with your client, why don't you do that for a minute, but otherwise.
I think I can just keep going unless you're dissatisfied with that response, Your Honor.
No.
I just feel like this level of kind of factual detail really should have been hashed out at the trial when everyone was there at the same time, at the same place. I'm not aware of any intentional screw-up or discrepancy. My client acknowledged in our brief that there was a repeat on some of the medical expenses, and that's played out with the judgment. There has been a judgment entered at the district court level for some of those medical expenses for the children, and we did subtract out the $700 that we acknowledged in the brief of Appellee. Did I cover that adequately for Your Honor?
Yes, thank you.
Another odd thing I heard today was a cult. I don't believe my client ever referred to the Mormon religion as a cult. Not that that really matters, I guess, legally, but I just want it to be clear for the record. My client is a practicing member of the LDS Church, and I believe the emphasis that Mr. Shuman has placed on religion in this case is just not appropriate. I recognize that Judicial Rule of Administration 4-903 does include religious compatibility as a factor, but again, that's mandatory on custody evaluators, and that was not appointed in this case. But even if one was appointed, my client doesn't identify as some radically different faith. She's not taking the child, to an atheist camp or a Sharia law. It's really not a question of which religion. It's just a question of, from the other side's point of view, who's the better Mormon? And I don't think that's appropriate, Your Honors. Do you have any further questions?
No, thank you. Mr. Weckel?
I went over a little bit there. Okay, so quickly these points. One is the guardian ad litem. The court had indicated, valued the guardian ad litem's comments, but ignored the fact that the guardian ad litem said that Mr. Shuman should be the primary caregiver, and that joint custody arrangement should be given to these parties. It totally ignores that. Okay. Secondly, the order that you folks, judges, were looking at initially, this order that was late in the day in the initial one, in terms of joint legal custody, it was signed off on by the commissioner and the judge. Okay, so whatever that order says, whether it's nunc-pro-tunc or whatever, my recollection is that it fixed the problem. It didn't use the term nunc-pro-tunc, but it implied that the original order was joint legal custody, and that's what it should have been. All right? Now, in terms of the school records, Your Honor, if a parent is putting her name and her husband's names on the school records and the medical records and not allowing the other parent access to that, yes, it is a denial of opportunity to get access to that, but it's also a misuse of the sole legal custody power, because certainly the parent has the right to get this information, because in this case it affected one of the daughters and he couldn't get access to that. So I think it's, that's an important thing. As far as the cult, that was actually in one of the court papers. I quoted it off the court paper. It's one of the early court papers. She presented no evidence whatsoever to back her points. We had 2 family members who were there. Okay, this is, and then, she had nothing. That's all I have. Thank you.
All right. Thank you both for your arguments today. We do appreciate it, and we will take this matter under advisement.